Hello students, in this lecture number 2, we are going to discuss the definition of jurisprudence given by the Austin, how the study of jurisprudence is different from the study of moral, ideal or natural law according to Austin. We will also discuss in this lecture the classification of jurisprudence into general jurisprudence and particular jurisprudence given by the Austin. We will also discuss in this lecture who support and criticize the definition and classification of jurisprudence given by the Austin. At the end, we will also conclude the definition of Austin. Now let us start the video from the definition of jurisprudence given by the Austin. Austin was the first jurist in the world who said jurisprudence is science. He defines jurisprudence as science of law which deals with the analysis of the concept or its underlying principles. That means to say, according to Austin, in the study of jurisprudence, we analyze the various concepts and various principles of the positive law. In the opinion of Austin, the appropriate subject to jurisprudence is the positive law. That means the law as it is, that means the law which is existing law, the law which is made by the state or which is made by the king. That means to say, in the study of jurisprudence, we are concerned with the positive law according to Austin. According to Austin, jurisprudence is not a moral philosophy of the law, but it is a systematic study of actual law, which is different from moral, ideal, or natural law. That means to say, according to Austin, actual law is different from the moral, ideal, or natural law. In this way, by giving the definition, Austin brings a new era in the field of jurisprudence, and many of his propositions still hold good today. Because presently we are also concerned with the law which is made by the state. In this way, Austin determined the province of jurisprudence. It determined what will be the area of study in the jurisprudence. According to Austin, the science of jurisprudence is concerned with the positive law. That means to say, the law which is made by the king or a state will be the subject matter of the study of jurisprudence according to Austin. According to Austin, in the study of jurisprudence, jurisprudence has nothing to do with the goodness or badness of law. And what was the classification of jurisprudence according to Austin? Austin further divided the jurisprudence into two categories. According to Austin, the jurisprudence may be the general jurisprudence and it may be the particular jurisprudence. According to Austin, general jurisprudence is the philosophy of the positive law. I want to repeat it here. According to the Austin, general jurisprudence is the philosophy of the positive law, which is not concerned with any particular system of law. According to Austin, general jurisprudence means the science which is concerned with the principles, which is concerned with the motions, which is concerned with the distinctions of the law, which are common to the different systems of law. According to Austin, the concept of rights and duties is common to different systems of law. In each and every system of law, this concept of rights and duties are discussed. The concept of ownership, possession, personality, property are common to the different systems of law in the world. So these concepts come within the study of general jurisprudence. Whereas, according to Austin, particular jurisprudence is confined only to the study of any actual system of law or any portion of it. For example, if we confine our study to the actual system of law of India, then it will be the particular jurisprudence. And according to Austin, the only practical jurisprudence, he regarded the particular jurisprudence as practical jurisprudence because it is concerned with the actual system of law of a particular country, of a particular state. According to Austin, the only practical jurisprudence is the particular jurisprudence. Okay, let us take an example by which we can understand what is the difference between general jurisprudence and particular jurisprudence. Ownership is one of the fundamental legal concept which is common to all the systems of law. It may be the India, America, Australia, Pakistan, China. In each and every system of law, the legal concept of ownership is existing. It is the function of jurisprudence to explain the nature of ownership and determine the condition under which the ownership may be acquired, the condition under which the ownership can be transferred, the condition under which the ownership comes to an end, that means to say extinguished. General jurisprudence discharges this function in which it explains the character and determine the condition under which the ownership is acquired, transferred, or extinguished without a special reference to any particular system of law. And when this concept is a discharge with the reference to the particular system of law, that will be the particular jurisprudence. Particular jurisprudence would also do the same thing of explanation, but it would do the same but with reference to a particular system of law of a country or a state. Okay, this was something about the definition of the Austin and classification of jurisprudence by the Austin. Gray and Allen agree with the Austin's classification of jurisprudence into general and particular jurisprudence. But Gray, who was very famous jurist, preferred the term comparative jurisprudence in place of general jurisprudence. Whereas there were also some criticisms made to the definition of Austin. First criticizers were Salmon and Jethro Brown. They repudiate the concept of general jurisprudence as was alleged by the Austin in his definition. Salmon, who was very famous jurist and is very popular among Indian students, had opposed to the concept of general jurisprudence. He says that jurisprudence is a science of civil law and it cannot be general, it is always particular. Okay. Jurists of historical school also denied the existence of general jurisprudence. According to them, like language, culture, and social atmosphere of a particular society, law also evolved in that way, which is always according to the local factors. And these local factors differ from country to country. And since these local factors differ from country to country, consequently, the study of jurisprudence also differ from country to country, and consequently only particular jurisprudence is possible and not general jurisprudence. But contrary to the view of Salmon and jurist of historical school, Holland also made the criticism to the classification of jurisprudence by the Austin, but he object to the Austin concept of particular jurisprudence. He argues that if jurisprudence is a science, and since the science is universal, then like all sciences, jurisprudence must be general and not particular. According to Holland, jurisprudence cannot be particular, it is general like a normal science. So, thereafter, it is very important to conclude the definition of Austin, even though there were many criticisms to the definition of Austin, but the analytical approach of Austin was understandable and practical when he make the classification of the jurisprudence into general jurisprudence and particular jurisprudence. The definition of Austin and classification of Austin attracted the attention of the jurists in other countries as well. Many English jurists working on the lines of Austin developed the study of jurisprudence further, and the study of jurisprudence came in its present shape. So, this is something about the definition of Austin. If you like my channel, then please subscribe it. And if you want to get the notes of my video lectures, then you can go to lawarticles2020.blogspot.com. Thank you very much.